You're watching a trial, and in the middle of the trial, one of the lawyers jumps up out of his seat like an ejection button was pressed and yells out, "Objection, Judge!" What does it really mean when an attorney yells out objection in the middle of a trial? You want to know the answer? Come join me on this walk through the neighborhood as I share with you the answer to that question. Hi, it's Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. It's a gorgeous day today here in Great Neck, and I needed to get out of the house for a quick walk during day 497 of the quarantine. Well, it's not really day 497, but it's a gorgeous day. The roads are empty. It's a beautiful Saturday morning. It's crisp and cool. And I thought this information would be really helpful to understand what really happens during the course of a trial. So this could happen whether you're watching something on TV, whether you're watching something in the movies, a courtroom drama, or whether you're actually in court watching a trial going on live. Now, at some point during the course of the trial, during the course of the proceedings, you will observe an attorney jump up out of their seat and yell out really nice and loud, "Objection, Judge!" First of all, why would an attorney yell out the word objection? You want to know the answer? The first thing it means is that there's a problem. This lawyer feels he has to alert the judge to a problem. And there could be many different problems. It might be a problem with the way the other lawyer is asking a question. And a question may not be phrased properly. It might be a problem with the evidence that the other lawyer wants to introduce so that the jury can see it. It might be a problem with what he expects this witness to talk about, claiming that it's inappropriate. There could be hundreds, if not thousands, of reasons why the attorney would want to alert the judge to a problem. So that's number one. So this attorney feels he has an obligation to actually make this objection. Now, when the attorney objects, what he's doing is he's interrupting the entire proceeding. He's getting everybody to stop. He's interrupting the flow of the other lawyer's questions. Now, that could be a strategy that the lawyer is trying to use to go ahead and interrupt the attorney's flow, his train of thought, to get the jury to stop what they're thinking about. That is a strategy that attorneys will sometimes use. Now, if you overuse it, it could be a problem. Why? Because when an attorney continues to object and they have no real legal basis for doing so, the jury will see right through it. And they'll recognize that the attorney is making objections for no reason other than they want him, that he wants to interrupt the proceedings so that everything gets sidetracked. And now the attorney will lose his train of thought, the jury will lose their train of thought, and you know what? At some point the jury is going to think, why is this lawyer trying to hide something? Why doesn't he want this witness to answer these questions? What is he really trying to hide, and why? If that happens, that will turn the jury against that lawyer and his client. And that's a dangerous thing. So many attorneys strategically and sparingly raise objections. Yet there are some lawyers who do it over and over and over again, believing that they have to stand up for their rights, they have to stand up for their client's rights, and assert those rights every single moment of every single time that it happens. Legally, that may be true. But from a logical reasoning standpoint, where the jury is now trying to learn information to decide who's right, who's wrong, who's more likely right than wrong, it may not be the ideal scenario for an attorney to go ahead and to object and look like a yo-yo, because now he's standing up, he's sitting down, he's jumping up, he's sitting down. Every time he has to object, he's got to jump up out of his seat, yell out, "Objection, Judge!" Now, what happens after the attorney raises an objection and yells out, "Objection"? Now the judge has to stop what he's doing, look up, and ask the attorney, "Okay, counselor, what's the basis for your objection?" And now the lawyer has to give a short, concise reason why he just interrupted the entire proceeding. "Counselor, what's the basis of your objection?" "Your Honor, that's hearsay." Okay, that's a one-word reason why. Now the judge will know what he's talking about. The opposing lawyer will know what he's talking about. The jury may have some idea, but they don't need to know right now because the judge is dealing with a legal issue. It's not for the jury to decide or to focus on. It's a legal issue that's now interrupted the proceedings. Now, he'll turn to the opposing lawyer and say, "Counselor, what do you have to say about that?" And then, after he hears brief comments from both attorneys, the judge will then have to make a decision. Do I agree with the lawyer who just raised that objection? He said it's hearsay. Either yes or no. If the judge agrees with the attorney who raised that objection, the judge is going to say objection sustained. And what that means is, okay, counselor, I recognize your objection and I agree with you, which means, Mr. Attorney, you are not to ask that question. Or, Mr. Witness, you are not to answer that question. Now, what if the judge does not agree? In that instance, he will turn around and say, your objection is overruled. Now, again, he's saying, I recognize you've made this objection, you've interrupted the entire trial, but I don't agree with you. So I'm going to overrule your objection, and now the witness can go ahead and answer. The attorney can go ahead and ask that question. That evidence will come in. Now, why again would an attorney raise an objection? The attorney will raise an objection primarily to protect his client's rights. So let's say, for example, that a question is being asked, and it's an inappropriate topic to talk about. And now the attorney says, Judge, that's an inappropriate topic. You already told us before the trial that we could not ask questions about that topic. If the judge does not agree, now if that lawyer loses the case, the attorney has the ability to argue in front of an appellate court and say, I raise an objection. The objection was appropriate. This witness should not have been asked this question. He should not have been allowed to answer this question because the trial judge determined that this topic was off limits. And now the appellate court will have to decide if that's true. If it is true, the case might be overturned. And now the entire decision would be different. So he'll argue, listen, had the judge done the appropriate thing, I would not have lost this case. So if the attorney fails to make an objection when he should have, and now tries to appeal and loses the case and then appeals it, the higher court, the appellate court, will look to see, the first thing that they will look to see is whether or not he made an objection at the time that this thing was happening, at the time that he realized that something bad was going on. If he fails to make an objection at that time, the appellate court will turn around and say, hey, counselor, where were you? Were you sleeping during the course of this testimony? Only now, after you've lost the trial, do you go ahead and read the transcript and realize, hey, there was a problem here, and what you should have done is stood up and made an objection and make the judge give you a ruling at that time. Now, if he did not make the objection at that time, he will have waived his right to address this issue on appeal. In which case, the appellate court will say, since you didn't raise the objection at the appropriate time, you waived your right to do that, and this is no longer an issue for appeal. You have anything else for us to consider? And that's a problem. So in order to prevent that from happening, the attorney will often go ahead and make that objection, even though he's going to get a ruling against him, even though it's going to interrupt the entire proceeding, interrupt the jury's train of thought, interrupt the opposing attorney's train of thought, because he's thinking that if he doesn't do it now and he loses the case, now if he goes up on appeal, the appellate court is going to turn around and say, hey, counselor, you lost your opportunity to raise this issue on appeal because you just didn't bother making that objection. I have found that some of the very best trial attorneys in New York, from a strategic standpoint, actually choose not to object, even though they have a legal right to. Now you might be thinking, I don't understand. If they have the right to, and they're given the opportunity, and they should be jumping up out of their seat yelling, objection, judge! This witness cannot answer that question. Objection, he's leading the witness. Objection, judge, he's badgering this witness. All of these objections may be appropriate, but from a strategic standpoint, the attorney may decide, you know what? I don't want to interrupt the flow. I don't want the jury's focus to leave what's going on right now. Besides, it looks like they're falling asleep. The defense lawyer is asking questions that's putting the jury to sleep. Why should I raise their awareness now to something that's going on? I don't really want to do that. Maybe it's after lunchtime. Everybody had a great lunch. It's a gorgeous day. It's hot in the courtroom. And now, guess what? By standing up and making an objection at that point, he may wake the jury up. The jury may wake up and realize, oh, what happened? What happened? What did we miss? And now start to pay attention to something that really is not very important. Or, if the attorney makes repeated objections, guess what? Now he runs the risk of having the jury turn against him, thinking that the lawyer is trying to prevent information from coming in, trying to prevent the witness from answering certain questions, trying to prevent the jury from learning as much information as possible about what occurred in order for them to make an educated decision about who's more likely right than wrong. So why do I share this great information with you? I share it with you because it's a gorgeous day today here in Great Neck. I needed to get out of the house and take a quick walk around the neighborhood. There's nobody here walking around. The roads are empty, thankfully. And you know what? I thought this information would help you understand how these types of cases would work, even if you're not considering bringing a case right now. But you will invariably watch a trial on TV, you'll watch a courtroom drama, you'll watch something in the movies, and in every courtroom scene, somebody is going to be standing up, or I should say, jumping up out of their seat and yelling out, "Objection, Judge!" And now you'll know exactly why they're making that objection. You know, I realize you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, but you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. Oh, and it figures there's a car right behind me now when I said it was totally empty. All right, everybody. Hope you have a safe, wonderful day. Be well.